On the 12th of March this year, Honourable Justice Bahati Mwamuye gave conservatory orders in our petition, that is Sharia Mtaanina Shadrao Kwambui versus NTSA and others, stopping the implementation of the instant fines management system that had been announced by the NTSA. Now, we need to understand that the giving of these conservatory orders was as a result of the persuasive arguments that we raised in the petition and the instant application that we had filed before the court. Now, over time, NTSA seems to have gone back to the drawing board, and they have today issued a notice suspending the implementation of that instant fines management system. And they have cited that they want the public to understand the implementation and the details of that system so that the public are not misled. And also, they want to align that system with Section 117 of the Traffic Act. Now, unfortunately, 117 of the Traffic Act is a vast act because over and above giving the Cabinet Secretary and the police service the powers to conduct investigations and issue fines, they seem to have forgotten that that is the preserve of those two institutions. If we were to look quickly at Section 117, which we have had the benefit of reproducing to the members of the public, Section 117 starts with informing the public that a Cabinet Secretary may prescribe two things. And the first thing is the schedule of minor traffic offenses. 2, a form of police notification of a traffic offense for use under this section. So we need to put that at the back of our minds, because it is interesting given that any notification that is supposed to come from any authority whatsoever ought to be in a prescribed form issued to a police officer. And if you look at to the definition of who is a police officer, the National Police Service Act provides that a police officer is an administrative police officer, a Kenya Police Service member, or a Directorate of Criminal Investigations officer, or anyone in the reserves. So at the back of our heads, or at the back of our minds, we need to understand that the only people under this act who are supposed to issue these notices are police officers. Now, if we are to go to Section 117(3) of the Traffic Act, it says that it shall be lawful for any police officer, and that is again why we need to insist and have at the back of our minds a police officer, that any police officer to serve either physically, that is personally, or 2, affixing prominently to a vehicle, and 3, which is now where the NTSA is trying to come in, through the usage of any electronic or mobile communications technology upon the owner or person in charge of a motor vehicle. So what this particular subsection says is that there are only 3 ways of giving notifications or these notices of, these minor traffic offenses. 1 is either personally, 2, by fixing onto your motor vehicle somewhere that is prominent, that is either the windshield or your side mirror, anywhere that is extremely prominent, or 3, using using electronic gadgets, which now in this case is the mobile phone. Now, once that is done, it does not stop there. If you go down, that is Section 117 subsection 4, 5, 6, 7, 8, and 9, it goes on to give us the strict procedure that ought to be followed. That members of the public, you have 2 options. 1 is to pay the instant fine, and if you pay that instant fine, This is the procedure according to the Act. Subsection 5 of Section 117 says that once this notification, which is ultimately treated as summons to attend court, if you choose to plead guilty to that offense, you are supposed to endorse in writing and hand over that notification to the court in which you have been summoned to. Remember, these notifications serve as summons. So you write to the court indicating that indeed you probably oversped and you have agreed to pay this particular maximum penalty, and you submit it to the court. Remember again, you submit it to the court. You do not submit it to a bank account that is controlled by someone we do not know. You submit it to the court, and the court, upon perusal of your handwritten plea of guilty, of being found guilty, is going to enter a conviction and determine from the representations you will have made from that submission whether that maximum penalty is going to stand, or two, if you've given enough sufficient mitigating circumstances, then the court imposes a fine and refunds what will be the balance out of that maximum penalty. So for example, if you have been caught overspeeding and the maximum penalty is 20,000 for that particular offense, and while you admit that indeed you are liable and you are guilty of that, but there were mitigating circumstances, you write to the court and tell the court that yes, I was overspeeding and I do accept it is my fault, but for reasons A, B, C, and D, I do not think that you should apply the strictest and the maximum penalty against me. So what the court will do, it is going to observe your mitigating circumstances, and if it finds that they are sufficient and credible enough, and decides to probably fine you 2,000 shillings, it is going to, in its court fine you 2,000 shillings and refund 18,000 shillings to you. So again, here is the issue of the bank account. This process, as the NTSA has made it, it is not that easy. This is because the judiciary is a stakeholder in this process. As we rightly stated from our initial court presser, that this is a criminal process, and the people who have the mandate to undertake the investigation, prosecution, and conviction of criminal offenses are either the police officers and the judiciary as a system in itself. Therefore, in its own wisdom, the framers of the Traffic Act go ahead and tell us at Section 117, capital B, it creates the preparation of a summary document. And the Inspector General, it gives the powers to the Inspector General of Police, not to the Inspector General of NTSA, to the police, to prepare a document showing the offenses set out in this act, including Section 117, which is the minor traffic offenses. And Section 117C, it bestows upon the officer commanding a police division being responsible for all traffic matters within the division, and all police officers shall be responsible for traffic matters. So our petition is very clearly set out that in the event that this withdrawal of that notice seems to probably hold a sway in the court of public opinion, our petition still stands. It is still legitimate and still valid, because these are questions which we raised in that petition. Therefore, we need to assure Kenyans that we are going to stick to this fight until we have held into accountability every government agency. Thank you.